Yes.
Thank you very much for attending this session on the cross-border competition law enforcement from the viewpoint of developing countries. My name is Akari Yamamoto Bononfon, a legal officer of Competition and Consumer Protection Policies branch of UN Trade and Development, UNCTAD. I'm not talking too long because the session is very short and I think we are ahead of time. But yeah, okay, sorry. But yeah, just for those who are wondering what is UNCTAD and what are you doing here, UNCTAD is a focal point of competition law and policy within the United Nations system. And in accordance with the mandate, given a mandate in this field of competition law and policy, given by the member states of UNCTAD, which is in 195 member countries, we first facilitate consensus building and communication, exchange of information between those member states. And also, we do research and analysis on the competition-related topics and other relevant topics. And also, we provide technical cooperation activities with the younger competition authorities, mostly in the developing countries. And all of those might explain to some extent why I am organizing a session on this particular topic. And yeah, I assume that not all of them attending in this event are necessarily very familiar with the competition law enforcement in the other regions than the North America and Europe, but competition authorities in those other regions, those are in developing countries, do have competition, cross-border competition law enforcement. They do have cases, and they cooperate with the other competition authorities, and they might have some unique characteristics in each of their region. And we are very fortunate to have a distinguished panel of experts with us today, and I am very honored to introduce them. First, we have Dr. Adano Roba, Acting Director General of the Competition Authority of Kenya. And next, we have Dr. Abdulaziz bin Abdullah Al Zoum, Chief Executive Officer of the General Authority of Competition in Saudi Arabia. And the last but not least, we have Ms. Andrea Marvan-Saltiel, Chairwoman of the Federal Economic Competition Commission, that's known as COFECE of Mexico, who is now, as you can see, joining online. And each of these leaders will bring unique insights from their respective regions and respective competition authorities where they have been directly involved in the challenges and successes of cross-border competition law enforcement. So we will now hear from each speaker in turn. And I would like to give the floor first to the Dr. Adano Roba, Acting Director General of the Competition Authority of Kenya. Thank you very much. He will provide insights into Kenya's approach to cross-border enforcement, particularly maybe within his area in the East African community, or probably much wider international competition efforts of theirs. So sorry for being long, but I will give the floor to Dr. Adano. Thank you very much.
Thank you very much, Akari, and I would like to thank first and foremost Leah for inviting us to this forum, which is an excellent learning forum for institutions like ours, which are much younger. The institution is about 10 years old. We are basically a national competition authority based in Kenya, and we regulate all sectors of the national economy. There are other sector regulators who are more specific on the sectors they regulate, but we look at competition in all aspects of national economy. Since 2019, we have had a cross-merger collaboration with the competition agencies in the region. There are 2 competition agencies where Kenya is a member of within the region. That is the East African Community Competition Authority. It's not well advanced in terms of implementation of the law, but they have been there for some time. We are a member of that organization. And also we are part of COMESA, a Commonwealth market for the region. So Kenya is a member of both agencies. And since 2019, we have collaboration and merger notification across the region. Particularly for COMESA, 2 or more mergers across the country will be notified to, will be filed with the COMESA, but notified to us. And we do our analysis and submit to COMESA. We basically rely on thresholds which have been set between the National Competition Authority, ourselves, and COMESA in terms of who should notify and who should notify to COMESA, and we should only notify to the national authority. Cross-border merger notification process is, we have seen, is important for a number of issues. One is to avoid contradictory decisions by the authorities in the region, and also it makes the process for transaction shorter within the region. And therefore we see that there's a lot of benefit carrying out cross-border merger analysis when there is parties with interest within the region. So those are the issues, and therefore the other aspect which I can also just mention is the African agencies as a kind of an informal membership of African Competition Forum, which is an informal sector where we come together and carry out joint research within the region, and we come together and do capacity building, and that's what we do as a cross-border aspect within our jurisdiction.
Thank you very much. Well, now I would like to turn to Dr. Alzu, CEO of the Saudi Arabian Competition Authority, and he will discuss the collaborative efforts in the Middle East area, perhaps, or between Gulf countries, and please share your successful examples of cross-border cases, as well as if you have challenges of harmonizing legal frameworks across the region. Thank you very much. You have the floor.
Thank you very much, and I would like to thank Lear for this wonderful event today, and also thank them to have me and my colleagues to speak about the situation of competition law in the region. Before I get into the subject, I would like to give an overview and some statistic about the region so we can have some flavor of the competition culture in the Middle East. In the Middle East, we have, in North Africa, we have around 22 countries who are members of the Arab League in Egypt. And I would say around 5 of them, they don't even think about having competition law or competition culture at all. And then so we are left with around 16 of them. Half of them, they are talking about they are going to have competition law in the near future, but they are, saying that for the last 3 or 4 years, but we haven't seen anything really serious until now. So we are left with 8 countries who are really a little bit serious about competition law and competition policy. 4 out of them, they have really independent organization that is really independent financially and administratively. And one of them is Saudi Arabia, and the second one is Egypt, and then Kuwait also is the third one, and we have finally Morocco also as an independent organization. So with that said, everybody would expect, the situation of a cross-border analysis will be very, very weak if you don't have that many countries who have really a competition law. So with the remaining that have competition law, we are looking at the countries who are really have great trade partners around, which is, for example, some of the countries in the GCC and some like Egypt, for example. They are the biggest competition partner, trade partner with us, and they are the one who are really important to us to, for example, sign some MOUs which can help us also to negotiate some, for example, merger deals, or maybe exchange some data, or maybe some help in the form of technical help. But the most also problem for some of the countries who have competition law, they have excluded so many sectors from the competition law. Take, for example, our greater partner as far as trade, which is the UAE, United Arab Emirates. They have excluded at least 8 sectors from the competition law. So this will give us really another hard situation to deal with some, cross-section or cross-border cases. But we still, in the process of trying to, force them sometimes through some trade, treaties and some like that. So we force them to have changed the situation and not have that many excluded sectors from competition law. This is what I can say, at least for the 5 minutes.
Thank you very much, Dr. Alzim. And next, joining us online is Ms. Marvan, chairwoman of COMESA. Sorry, I was thinking about COMESA. I'm very sorry, COFESE. So
don't worry.
She will offer insight into Mexico's experience, and thank you very much for connecting online during your busy time. And the floor is yours. Thank you.
On the contrary, thank you for having me. I am terribly sorry I'm not able to join you personally or in person there, but I'm very happy to join the conversation online. Thank you to Lear and to UNCTAD for organizing this event, and also I'm very honored to be here with my colleagues Adano and Abdulaziz. So first of all, thank you. I can, similar to my colleagues, I can share some perspectives from the Latin American region and the American region. So, because Mexico, we are part of North America, which is just comprised of 3 countries, the United States, Canada, and Mexico. But at the same time, Mexico is part of Latin America. And Latin America and the Caribbean is composed of 33 countries, which are Latin American fellow agencies and fellow jurisdictions have very similarities, cultural, economical, historical, and so we share very strong bonds. But to that extent, international cooperation and integration in the region has been something that has been in the Latin American region, and we have been working and pushing for that for a while. One of the key aspects, as they were mentioning, is considering our trade partners and our biggest trade partners. So just to give you a brief context of COFESE, COFESE was created 30 years ago. And something that is interesting when you compare us to other competition agencies, such as our northern neighbors, which is the United States, who had a competition agency created in the 100 years before us. Our Mexican Competition Agency was created as part of the negotiations of the free trade agreement between the U.S. And Canada, and that's why our competition law was enacted. However, I think competition law, even though it's key, as they were mentioning, for for trade and regional integration, considering the economic circumstances of many of our Latin American countries. I could talk about Mexico. Mexico, we have a very we have an economy where you have very big players and then you have very small players. There's very big differences. You have a very big informal economy. About 50% of the participants in our economy are informal players. So even though the reality or the circumstances under which the Competition Commission was created, I think we owe a lot on competition enforcement. And that was just to give a little bit of context. Now, the role that we play in Mexico is we have collaboration and strong bonds with our North American partners, but also with Latin American. And I will just give a brief overview. These two fronts of collaboration are, as they mentioned, I was very impressed. We don't have that, but what Adano was saying regarding merger review and regional merger review, I think that is a great initiative. However, we do collaborate in mergers that affect more than one jurisdiction. So from the enforcement side, we have a strong collaboration regarding mergers and also in some investigations. Collaboration is deepened, I think, due to a number of circumstances, one of which is working constantly on communicating and exchanging ideas with other jurisdictions, and that has led us to sign. We don't have only for North America, we do have our free trade agreement, which has some chapters on competition, but in the Latin American region, what we have done is signed MOUs and collaboration agreements with different agencies. We have collaboration agreements with Brazil, with Chile, but also with Caribbean countries. We will be soon also signing a collaboration agreement with Uruguay. Most of our collaboration agreements are actually with Latin American countries. And that is how we have managed to collaborate. And then I would just like to mention not only on the enforcement side, but also on capacity building and exchanging experiences. We try to work very closely with our Latin American fellow agencies. We have an initiative which is called GRACA it's a short name, but which is called GRACA, which is comprised of all the Latin American and Caribbean agencies. This initiative was created a few years ago, but it's beginning to build strong bonds between us. We meet once a year, and every time we meet, we create an agenda of common issues where we all discuss these issues. So I think I would like to have such a strong collaboration as they have in the African region, but although I think we haven't achieved that, the Latin American region is becoming stronger, and our collaboration, mainly through collaboration agreements and advocacy efforts, but we have also managed to have cross-border, or not cross-border, but investigations or mergers that affect more than one jurisdiction, and in those cases, we have managed to collaborate effectively.
Thank you very much. And if I may, I would like to do the second round of question. And the speakers have kindly explained their collaborative frameworks, including the regional, regional groupings and networks on the COMESA and EAC are regional organizations, rather than anything. But if I may, I would like to ask all the speakers to share your experiences in actual cases, your experience in collaborating with other other competition authorities in any actual cases, to the extent that you can mention. So can I start with Dr. Adano? Thank you very much.
Thank you, Akari. I think our law is more modeled around the Commonwealth or European law. And therefore, our analysis for most of the merger cases follow the same analysis. We have not had any enforcement or cartel case where we have done jointly. So what I can emphasize is only mergers where we have worked together with COMESA largely. Because as I said before, East African Community Agency is not well advanced, and they are making the tools for them to enforce. So our only engagement for merger filing and analysis is with COMESA. And we have done a number of engagement where we have done joint analysis for cases, for merger transactions where substantial part of that transaction fall outside Kenya. And therefore, what we do in that case is we have basically two approaches. When the threshold is met, we do competition analysis, do the tests, and also we have public interest consideration, particularly around employment. We give either in cement or in beverages. We have recently done joint analysis where for the beverage company, they have shareholding in Kenya, and also they have presence in Kenya as well. But substantial part of it is in Rwanda. For that particular analysis, we approved the merger with condition, particularly for public interest, which is employment. For the cement company had only indirect control in Kenya. We didn't have presence of that company in Kenya. And the company is domiciled in Rwanda, which is one of the East African Community member states. And therefore, that one we did not look at employment as such. We only looked at competition tests, and we approved the merger without conditions for that particular case. But also there are instances in financial sector where we have seen that according to COMESA analysis, the merger will be approved without condition. And for this particular bank, there are presence in Kenya, and there are certain public interest consideration. And in such instances, then we ask for referral. COMESA will do the analysis and approve as no condition, but our component in Kenya is referred to as we look at analysis and provide conditions, particularly with public interest. And we have done that for 1 year period where there are likelihood of loss of employment by workers. And then we approve with those conditions, and they comply with our condition for the sector or the segment that is within our jurisdiction. And that's how we work together with COMESA. And we have referral, and otherwise we approve only when we have done the analysis for competition and also for public interest consideration. Thank you.
Thank you very much. Very, very interesting. So, yeah, the same question to Dr. Alzum. Thank you very much. The floor is yours.
Actually, we have so many cases that have cross-border effect in Saudi Arabia. But the first case that tested us and opened our eyes big to the importance of cross-border collaboration is a case involved the cigarette industry. The big firms, Philip Morris and the Anglo-American company, and also the Japanese corporation. That's, three companies. In 2020, the government decided to change the packaging of the cigarette and put those, ugly cancel patient pictures on the side of the packaging. And so those companies decided to retaliate against the government. So what they did, they decreased the grades or the quality of the cigarettes. And what happened, they created public cry in the whole country. Nothing worse than if you are a smoker not to have your desired nicotine in your body. So what they did, they just changed the quality. And so we decided to do a raid for the distributors of the cigarette of those companies in Saudi Arabia, and we couldn't find any evidence within the country. And we took the cigarette to some lab internationally, and we found out what have they changed. And they did the same thing. All of them, all the three the companies, they did the same change of the cigarette, which is actually the white paper circling each cigarette. So that destroyed the flavor of the cigarettes. But as I said, we could not do anything. But at the end of that case, actually, it turns against the colluders, those who collude together, because some of the social influencers in the country did a campaign against these three companies to shift to the companies that did not participate in the collusion. And for that reason, actually, what happened, they lost a lot of market share, and they did not regain it until this moment. The other case that we had is in the merger control, and that was in 2021 also, between Careem and Uber. Careem is a company originated in the UAE, United Arab Emirates, and gained ground actually by expanding first in Dubai area, and then it moves to Egypt and Saudi Arabia and Pakistan, and then to Sudan, and around maybe 11 countries. So they came first to work in Saudi Arabia, and then Uber came after that. So Uber could not really do much of competing with Careem. Careem is a lot more efficient than Uber at that time, especially in their mapping. So what happened, they filed for merger to buy up Careem. And we actually, this is the first case where we coordinated with each other, especially with Egypt and Pakistan and Kuwait, to analyze this merger. We were very much, helping each other in the definition of the market, and also on exchanging some research paper in this subject. And we find very good research paper, whether in Philippines, because Philippines had Uber merge with Grab, and also in Singapore, they did the same with Grab. So those papers actually helped us a lot to understand this merger and place the right condition on this merger. And we had around maybe 10 conditions. The most important ones is not to increase the price for the next 3 years. And also, the other one is to not having exclusive deal with the drivers. So anybody who want to come to the market, they can use drivers, or they can have available drivers. And also, we impose on them also for any newcomers to use Careem, maps, because they are more accurate than Uber. And there are also some more condition.
Thank you very much. That was also very interesting. So yeah, I would like to move again to Ms. Mahvan. Yeah, please share with us any of your experience in collaboration in actual
Yes,
cases. Thank you.
I'll be very, very happy to do that. We've had collaboration with Latin American agencies and with North American agencies in mergers and in enforcement. In mergers, one of recent mergers where we collaborated with the U.S. and the North American partners were related to door locks. I can't give like a lot of details. That was a transaction that was recently approved, but in many or most mergers, because of the trade integration in the North American region, many of them involve the U.S. and Mexico. So in those cases, we constantly and usually communicate on regarding what we're looking at, which information we're asking for, etc. Regarding Latin America, a case which we reviewed, it's I don't know, I found it a little interesting because it was also related to Uber, but it was Uber Corner Shop in Mexico, which in that case, that was also a multi jurisdiction transaction. And we had a strong collaboration with our Chilean fellow agencies from the Fiscalía Nacional Económica. Uh, and then currently, we in the cartel part, we, for example, we just announced an investigation. We've been doing it for a while, or it's been open for a while, but we just made it public recently regarding fragrances. And that investigation is also being reviewed, or well, that is also being reviewed by other jurisdictions in competition jurisdictions. And in that case, we have been collaborating with the DOJ and with the CMA. But I would like to mention uh, uh, one initiative which I think has both enforcement and advocacy. Um, I myself, I am a very big football fan, or soccer, depending on which part of the planet, or who is the audience. But I don't know if you're aware of this, but in 2026, Mexico, US, and Canada, we will be hosting the FIFA World Cup. And what we have learned from other agencies who've have their countries have hosted similar events as the World Cup or the Olympics is that during these events collusion tends to happen because governments spend a lot of money um, regarding the construction of sites, or etc. There's a lot of public spending, transportation to get to and from the stadiums, etc. And so actually this is something that we've learned thanks to exchanging experiences with other agencies, especially the Brazilian agency, because they hosted the World Cup and the Olympics in a very short period of time, and they found a lot of cartels that went around the public spending, uh, specifically or mostly regarding to public procurement. So we launched an initiative with the US and Canada in order to prevent and monitor any cartel conduct that could go around the FIFA World Cup. And as I mentioned, this is an advocacy and an enforcement tool because, first of all, we are reaching to the governments and to the cities that are going to be hosting the soccer games uh, to learn what they will construct or what they will contract or how much they will spend, and to advise them and help them design competitive tenders and then also monitor the tenders. But the reason that the initiative, as I mentioned, is joint because there might be some cases where there might be similar companies or undertakings that are going to be involved. And so it starts with advocacy, but we will be monitoring closely the markets. And if there is a collusive or a competitive conduct, then each country will conduct its own investigation, and then we'll probably cooperate along the way.
Thank you very much. Again, yeah, thank you to all of the speakers for their valuable insights. And do we have time for questions and comments from the floor? Okay, so I would like to open the floor for any comments or questions to the speakers.
Hello, this is Marcello Cramazza. I'm head of antitrust at Clariant, based in Switzerland. And thank you for the very comprehensive overview of the activities. And of course, as a company engaged in many countries, we are looking at the developments not only in Europe, but also in other regions of the world. I have a question with regard to cross-border cooperation in investigation. I understand from Ms. Varvan that they are involved in the fragrance investigation, which is, of course, one of the biggest investigation now ongoing involving many authorities, and so it's very worldwide as a scope. Maybe are the authorities in the Saudi Arabia and in Kenya also being involved, or is the aim to being involved for, you know, a larger cooperation, not only regional, but maybe more at a global level for, you know, high-level investigation? What's your view on that? Thank you very much.
Very much. Would you like to go first? Then please, Dr. Adano.
Yeah, thank you very much for that question. We have done a few cases relating to investigation on our own. We have not done any investigation with regard to cross-border issues. The last time we did, it was in the steel sector. We were not able to do with other agencies because of lack of capacity. They have not done before, and we have seen that most of the evidence were actually gone online, digital. Most of the evidence we retrieved from their devices. We had to work with the anti-corruption agency locally, which had those forensic equipment to allow us to extract the evidence. And other agencies did not have. And the main challenge we had then was, how can we involve them? Because the same companies that are in Kenya are also in the region, but they have not done any work before, and therefore it was risky for us to expose ourselves before we do the run rate to them, because this is a very secretive sector, as you know. We couldn't do that particular one alone with them. So we did it alone. What we have done with them is research, joint research. We conduct joint research in the sense that we developed an harmonized multi-year work plan that allows us to harmonize our activity within a year by creating a technical team across the agencies that drive this process. So we have done joint research, but we have not done any dawn raid or cartel cases in the region so far.
Dr. Azum, please.
We haven't done either something in the international setting, but we did it within the neighbors, like especially in the GCC countries. We have coordinated some of, cartel possibility in one of the cases. But actually, what we need to do first is to work on our legal system, because we still have differences between our legal system and some of the international legal system. And recently, we are working on the leniency program, and we want to have similar flavor with the international leniency programs also, so we can move into a bigger picture with some possible, cartel cases in the international setting. So we are working to harmonize, in general, some of the legal, setup in the kingdom, and then we will move to sign some international MOUs. So that will help us also to tackle some of the big cases, whether it is cartel or abusive dominance or what have you.
Thank you very much. Ms. Malvan, would you like to add on this point?
Well, I think I can only second what my colleagues have mentioned. I think the starting point that helped us start cross-border investigations was, of course, our legal systems can't be exactly the same, but to have some principles or the same principles, and definitely our leniency program. Our leniency program has existed for about 15 years now, almost, about 18 years now, and creating a leniency program with clear and transparent rules, and which has been maturing and has been evolving, has also helped us have more transnational cross-border investigations. Not referring to a specific investigation in particular, but the leniency program, along with strong enforcement tools such as Dawn rates, is what has helped us again be able to conduct and to cooperate in these trans-border investigations.
Thank you very much. Now, I think we're running out of time, but yeah, please go ahead.
You know, I personally am very interested in the competition policy in other jurisdictions in other parts of the world. At LEAR, we've done some work across the world. You mentioned some countries such as Egypt, Kuwait, Saudi Arabia, Morocco. We have worked in two of them, Egypt and Kuwait, and we have done some work in Kenya as well. And the purpose of our work is to help them building the competition policy, basically. So I was interested in knowing what are the things that you think you need the most to make your competition policy more effective, even domestically, not necessarily across, borders. And I don't know, in terms of resources or you mentioned leniency programs, power to impose sanctions, down raids, power to do investigation. What are the things that you think you lack at the moment and you need to make your intervention more effective?
Thank you very much. Yeah, I think it was a very supportive remark to the session.
I would like to answer to this. I mean, in Saudi Arabia, we are very active in competition policy. Recently, we have worked on the national competition policy, and I think Dr. Sean was with us in that study, and we finished it a year ago, and we sent it to the government, and we are waiting for the government to decide on this competition policies for the aggregate economy as a whole. And most of it is, applicable, like, for example, changing the regulation within the government that had some problems with the competition law, and some other policies too. And also we do public policies within the studies that we do yearly, and we usually do 3 studies about some sectors. And at the end of each study, we do publish some public policies, and we share it with the regulator of the other markets. And for the last 5 years, we continuously do 3 studies and share the public policies with regulators. And we finish until now around 15 studies so far. So we take public policies as a serious subject. We think it is very important, and it is an ex-ante tools to solve the problem before it becomes really a case that bothers everybody, especially some of the companies.
Thank you very much. Yes, please.
Yeah, thank you very much for that important question. I think that's a very important question with regard to domestic issues when we look at the competition law and competition policy. One of the things at the moment, I think, is the digital issues in terms of the skills that is required to carry out what is required. And it's an area that we got support from EU in terms of the African Week and also placements at Brussels. On a year basis now, we have 1 person being placed there. The other important aspect, in my view, is collaboration with other sector regulators who have substantial part of the data, but they are not forthcoming when we become proactive and reach out to them to provide the data to give us evidence that are key for decision making. What we have done this year is to propose drafting a framework, a competition policy, that within it allows us to coordinate with other sector regulators competition issues. We have started the process, and of course, the key resource that is required is financial. We are looking for how best we can raise it, and with the current economic situation, that might require more lobbying from the relevant institutions. But that policy, in our view, will entrench a coordination unit that give us duties to look at how can we coordinate with other sector regulators nationally. And that allows us to bring a forum of other regulators under our umbrella and our coordination on matters competition and consumer welfare. And that's what we are working on at the moment, beside amending our law with regard to digital issues and digital platform and digital markets.
Thank you very much. Well, Ms. Malva, could you share the COFES's initiatives? Thank you.
Yes, I think that is a key question, and thank you for making the question, because as you mentioned, I think although competition policy is key, and I think all of us can agree on that, because competition allows consumer to pay less and to have more options. And there has to be, from my point of view, the competition law has to have these core principles, and I think some key components such as cartel enforcement, abuse of dominance, pre-merger review, I would say strong sanctions, and then strong tools to investigate. But these 5 components have to be used according to the necessities of each country. And I think that is the point that you made in your question is absolutely key. Because if you don't apply competition policy with these core principles, but to the necessities and the reality of each country, then competition policy might not reach its core objectives. I think, for example, something that has been happening not just in Mexico but in other jurisdictions is there has been a questioning of consumers, of small and medium enterprises, of what has competition policy done for me. And I think that is something that when designing the competition law and applying it, we all have to take into consideration the reality of the country. As I mentioned, in Mexico, 50% of our economy is informal. A larger, even, and you have a very, there's a very big contrast between some very few big enterprises and a lot of small, medium enterprises. So in that reality, what can competition policy do? And a point I think that was just made by Adano, which I think is also key. Competition agencies, we are in charge of applying competition law and competition enforcement. However, I think competition law needs to be a matter of state, because you can have a competition law and you can have a competition agency. But if the regulators and the legislators and other participants and stakeholders don't actually understand the importance of competition and commit to competition, then the leeway or how much the competition agency can contribute to that is going to be more limited. So I don't, there's probably not a secret recipe. Oh, I need to, give me a sec. Yeah, no, that's good. This is going to sound crazy, but we've had in Mexico some small earthquakes, and we just had a small earthquake. Everything is fine. But just to conclude, there's not a secret recipe, but I think you need to have key components and adapt them to your reality. And I need to go because now we're going to move to the elevators because of the earthquake, but everything is fine. Thank you for having me. Bye.
Thank you very much. So yeah, I think this is a very good time to conclude for us. So yeah, again, yeah, although Miss Marvin is already leaving, but I would like to thank our panelists once again for their sharing their experience and perspectives. And I also thank you for your attention.